On Monday, a federal judge in Nevada lifted a permanent injunction about parental notification before a minor can have an abortion. A law passed in 1985 requiring at least one custodial parent to be notified before a minor can have an abortion, but the injunction was granted in 1985 because the court found it violated Roe versus Wade. Well, the court on Monday cited the U.S. Supreme Court's Dobbs decision as the basis for lifting this injunction. Now, the 1985 law requiring parental consent goes into effect on April 30th. So what are the requirements of that 1985 law? Why was that injunction lifted? We kind of told you a little bit about that. And why are the legal issues for patients and doctors responsible for this going forward? So here to discuss that all, we have Matthew Hoffman with us from Battle-Born Injury Lawyers. And this is one, again, as we mentioned in that intro, that dates back to a 1985 law. Now that we have Dobbs in effect, things are starting to change.
Yeah, because I mean, you go back to 85, and I think this law was written to try to get around Roe versus Wade back then. That's why it doesn't say parental consent. It's just parental notification. But regardless, it was deemed to violate Roe versus Wade and never went into effect. There was an injunction put in place to put it on hold, and then eventually that became a permanent injunction in 1991. So the law has never actually gone into effect. And what it basically says is that if a minor wants to get an abortion, one custodial parent must be notified. Hey, this is happening. It doesn't say they have to give consent. It just says they have to be notified. And the state interest in this is that parents should know what's going on with their children, is the idea. That's the justification behind the law. Now, there's more to it than just, hey, you got to get permission. A minor who wants to get an abortion, maybe they don't want the parents to know. Maybe there's something bad going on at home, what have you. So there's exceptions. If you're already declared an emancipated adult, it doesn't apply. If you're a minor who is married, it doesn't apply. Or you can go to the court. You can go to any district court and you can ask for an interview with a judge, and it has to be granted within 2 judicial days. So weekends don't count or holidays.
Right.
But within 2 days, you're going to sit down with a judge. It's all confidential. You basically plead your case. And then the judge has very wide discretion on whether to grant the ability to go get the abortion without parental consent, as long as they feel that you're making a competent decision. Perhaps there's a risk of harm if your parents were informed, or they feel like you are an emancipated adult that just hasn't been formally declared, whatever it is. The next day after that interview, so 3 days total, the judge has to issue an order one way or the other. And if they don't, it is deemed granted. So none of this has ever been tested in the district courts, right? Because the law never went in effect. My guess is that the district courts, which I can tell you personally, are very, very overwhelmed. They will respond to this if there's a lot of these petitions, and probably have a group of judges assigned that will do, hear all of these.
Yeah.
And my guess is that most of them just won't have a ruling, because by default, they're granted.
It's granted, yeah.
You know what I mean? So practically speaking, I think there's going to be a workaround for most people.
But isn't the onus to make sure that this is complied with on the medical workers?
It is.
The provider?
And the way that's going to happen is that if a minor presents to get an abortion procedure or medical abortion, medication abortion, I think the providers are just going to say, look, we're not doing this unless you get. They might even require permission, which they're free to do. Say, look, we're not going to do this unless we have some kind of proof that you have consent of your parent, knowledge of your parent, or if you come in with a court order. I think that's practically what's going to happen. So, the law is going to go into effect April 30th of this year. That's the effective date by the judge, and legislature's in session.
I was just about to say, I could see why parents would want this, but do you anticipate any opposition? And we are in session right now. Anything coming out of that to answer to this?
Yeah, so I think you might see something trying to reverse this law from 85 before it goes into effect on April 30th. I just don't know how much appetite there would be by our governor. He has declared himself a pro-life governor, although he has passed and signed a law that forbids state agencies from cooperating with other states that want to prosecute people who come here for abortions. But he is pro-life. And I think more to the point, I don't know how much political appetite there is given the limitations of this law only applying to children, minors.
Yeah.
I think most parents would want to know if their child is looking at getting an abortion. They might not even know they're pregnant. So will it be solved politically? I doubt it. It could be appealed, But given the Dobbs decision, it's left to the states, and all you have to do as a state to say, look, we have a rational basis. We have a legitimate interest in parents knowing what's going on with their kids, and this law is rationally related to that purpose. The test is much, much lower because under Roe versus Wade, it was a constitutional right. That's a strict scrutiny standard, the highest standard. Now it's just the rational basis test. I think this passes it, and so I don't think it's going to go away in the court system.
Yeah, and then there is that provision for if someone did think notifying their custodial parent would cause them harm or somehow be an adverse situation. So interesting. April 30th is the day that it's going to take effect.
And I think it's gonna stick. I just don't think it's going to be solved legislatively, at least not this session.